Hello friends, welcome back to Pen and Paper YouTube channel. So here we simplify complex legal topics using just pen and paper. So today's topic we have is the what happens if you die without a will in India. So let's break this topic clearly, visually and legally. So let's start. So friends, first we need to see what is a will. So basically, a will is a legal declaration of your wishes regarding the distribution of your assets. So basically, this is going to come in force or effect after the person who has written the will after his death, and it is also going to be governed by the Indian Succession Act 1925. So basically, the sections under this act are going to cover from section 57 to 73 for testamentary succession. So, very simple. A will is a legal declaration of your wishes regarding the distribution of your assets. So, whenever someone who is going to die by writing a will, so he is going to declare that who is going to be what, the distribution of the assets after his death, and basically it is also going to be governed under the Indian Succession Act, that is 1925. Okay, friends, and now let's try to understand with an example. So here is Mr. Raw. So basically, Mr. Raw wants his daughter to inherit his house. So he doesn't want to get to his wife, to his sons. He just want to his daughter to inherit his house. If he writes a valid will, then that wish is honored before he is going to die. If in case if he is going to die without writing a will, then the law is going to decide, and also it may not reflect his intent. So whatever Mr. Raw has thought that his house is going to be inherited by his daughter, so it is not going to be the one whenever the law is going to decide. So there will be a share of the wife, the sons, and everyone. So likewise, so if in case a person who is going to write a valid will, then definitely it is going to become effect after his death. If no, then definitely the law is going to decide the shares what who is going to get, even though it is against the will of the person who has died. So friends, now we will try to understand a very important aspect here. So what does dying intestate means? So basically, dying intestate is going to mean whenever passing away without a valid will. Suppose there is a person, he has no will written, then the legal heirs are going to inherit according to the law. And if in case anyone who has died without a proper will, in these cases, the succession is going to be governed by the personal laws of the family or the persons who have deceased. Otherwise, it is going to be governed under the Indian Succession Act 1925. So, depending on your religion. So, for example, Mr. Iqbal, a Muslim who is going to die without a will, so his estate is divided under the Islamic inheritance rules. So his wife is going to get 1/8 of the share, and his son is going to get the twice the share of the daughter, and the parents receive the fixed portions. So he could not choose differently even if he has wished before. So this is very important. If there is any person who has died without writing a will, then that is going to called as dying intestate. So friends, now we will look into the Hindu Succession Act, how it is going to be governed if in case anyone who is dying intestate. So basically for Hindus, Buddhist, Jain and Sikhs, so intestate succession is going to governed by the Hindu Succession Act 1956. So basically section 8, which is going to govern the general rules of succession for males, and section 5, 15 to 17 is going to mention about the succession for females, and there is also a schedule for the list for the class 1 and the class 2 heirs. So this is very important. And we will try to see this with an example. So if there is a Mr. Sharma who is going to die intestate, so he has not written a will, then the as per Hindu Succession Act, his wife, his son, his daughter and mother are eligible for to inherit the deceased property if in case the class 1 heirs do not exist, sorry. So if these people are not existing, then definitely the class 2 heirs like father or siblings are going to inherit the Mr. Sharma's property. So very simple. As per the Hindu Succession Act, if in case someone is dying intestate, then this is going to be governed under the Hindu Succession Act 1956, and the key sections going to include the Section 8, which is going to mention about the general rules of succession for males, and there is also Section 15 to 17 we have under the Hindu Succession Act 1956, which is going to mention about the succession of for females. And then we will be also having the schedules under this act, which is going to provide the list of the class 1 and class 2 heirs. So heirs are the legal heirs of the deceased person. If in case class 1 is not existing, then class 2 heirs are going to inherit the deceased property. So this is very simple in Hindu law. So friends, now we will look into the Muslim personal law, that is also going to called as Shariat Application Act 1937. So intestate succession. So if in case any Muslim who is going to die intestate and the succession is going to governed by the Muslim personal law, that is the Application Act 1937. So here section 2 is going to mention about the Islamic law applies to inheritance, which is going to override the local customs or the general law what we have for the succession. So we'll try to see this as an example. So if in case there is a Mr. Ahmed who is going to die intestate without writing a will, so his wife is going to get 1/8 of the shares, and then sons are going to get the twice the shares of the daughter, and then parents are going to receive the fixed shares. So these are the Quranic mandates, and these are not discretionary, which we are going to have. So likewise, this is going to be governed under the Muslim personal law, that is Shariat Application Act 1937. So friends, now we will look under the Indian Succession Act 1925. So here Christians and Parsis are going to be governed, and for Christians and Parsis, the intestate succession is going to governed by the Indian Succession Act. So where the key sections under this act are going to be from the 32 to 49. So this is going to apply for the Christians, and from section 50 to 56 is going to be applied for Parsis. So friends, under the Indian Succession Act, apart from Hindu and Muslim, so the Christians and Parsis are going to govern under this act. So the sections under this act from 32 to 49 are for the Christians, and for 50 to 56 there are special rules for the Parsis, and there are rules for the Christians. So now we will try to understand with an example. So there is Mr. D'Souza who is going to die intestate. He has not any will before he is going to die, and uh, her husband and two children get 1/3 of the her estate. So under section 33 of the Indian Succession Act, so this has been defined. So if Mrs. D'Souza is going to die intestate, Mr. D'Souza's husband and two children are going to get 1/3 of her estate under section 33 of the Indian Succession Act 1925, and likewise this is also going to be governed for the special rules for the Parsis from section 50 to 56. So friends, now we will try to understand legal heir and succession certificate. So for any person to claim property he must obtain a legal heir certificate. So this is very important. You need to first obtain the legal heir certificate, which is for the general purposes we have, and we need to also need to have a succession certificate. So these are the two important documents we need to have whenever we need to claim property for any of the deceased person. Maybe they are the family members of that deceased person, maybe the wife, the children, class 1 heirs, class 2 heirs, their father, the parents. So what they need to do is they need to have the legal heir certificate, which is for the general purposes we are going to use, and there is also a succession certificate. So this is under section 372 to 379. So basically the succession certificate is going to be governed under section 372 to 379 of the Indian Succession Act 1925. So basically this is for the movable assets like bank accounts. So these two are going to play very important role whenever you are going to claim the property, and the legal heirs need to have these certificates. So friends, now we will try to understand with the example. So there is a Mr. Patel. After Mr. Patel's death, his daughter needed a legal heir certificate to transfer the house and succession certificate to access his fixed deposit. So these are the two documents, very important documents. So whenever there is a legal heir who wanted to have the transfer of the immovable property, they need to have the legal heir certificate and the succession certificate for the in case there are any fixed deposit or the account for which the person has deceased. So then these can be claimed by the legal representative or the legal heir. So friends, now we will look into how the property transfer process is going to happen. So the process is going to include that we need to have the four important things. That is, first one is the death certificate of the deceased person. Then we need to have the legal heir certificate, and then we need to have the mutation certificate, which is for the properties, and we need to also have the notification to the banks, societies, and registers. So accordingly, they will be notified. And if it is an immovable property like house, then definitely we need to have the mutation documents, that is the mutation of the property. And if in case it is a fixed deposit or a savings account, then we need to notify the banks, societies, and registrars regarding the transfer process. So friends, now we will look into the family disputes and delays, which is which is going to happen whenever a person is going to die intestate. So without a will, disputes are going to happen, which are common nowadays, and legal battle which can stretch for years, causing emotional and financial strain. So the deceased property and the financial things which is not going to settle, so then we will be moving to the court, and there is a big legal battle which can go for years, which is going to cause the family members, that is the emotional as well as the financial strain. So for example, three siblings are there who fought over their father's flat for 6 years. So the reason, because there was no will the father has written. So there were three siblings. They are going to fight in court for the legal battle to get the property share, because the father has not written any will before he is going to die. So the court had to decide who get what. So what portion of the flat, maybe after selling, or the if in case the flat is going to divided among the siblings. So likewise, so the court is going to decide here if in case there is no will written or the person has died intestate. So friends, now we will see why you should make a will. So every person who is going to have the property and the financials, definitely they should make a will. So because there are the disputes which are going to avoid, like in the above example, we saw the siblings went to the court for a flat and then it went for years. And if there is a will, it is going to transfer very quickly, and everyone is going to have the clear intentions. So a will ensures your wishes, which are going to be respected, and then these are going to avoid family conflicts, and which is also going to speed up the property transfer. If in case you have the will written by the deceased person, then the legal heirs can take that will, and then they will speed up the process of the property transfer. So it's a simple act of a person who is holding a property or the financials before he is going to die, and it's a powerful consequences of this if he is going to write the will. So friends, this was pen and paper channel where we simplified the legal concept which was very complex. And if you find this video helpful, please like, share and subscribe to our channel. So we'll see you in our next video. Until then, take care. Bye.